Good afternoon, everyone. We're going to go ahead and get started this afternoon. I'm going to give everyone about 30 seconds to a minute to get logged in to confirm that what you see on the screen are 4 panelists for today, as well as a copy of the presentation before you. From an audio perspective, you should be able to hear audio either coming through your speakers on your computer or via your phone line if you've dialed in using audio. If you have any trouble and you can't hear, you want to be able to use the audio box on the right-hand side. This presentation is being recorded so that you can go back and have access later for playback. And with that, I'm gonna turn it over to Kim Calloway, the Director of Legal and Governmental Affairs for Louisiana Realtors, to do the introductions for our panelists and speakers today. Yeah.
All right. Hi, everybody. We welcome you to the second of our webinars on evictions during COVID-19. Just a little disclaimer. The material you're going to hear on this webinar today is accurate as of June 4th at 2 o'clock. Things are changing daily. We do expect Governor Edwards to issue another proclamation today that may have an impact. So please continue to check our website for future updates. And as we've explained in previous webinars and materials that we've posted, evictions have been suspended indefinitely right now. Hopefully they'll open back up on June 8th, but we don't know. And that's not including the properties that are covered by the CARES Act, which you'll hear more about in a little bit. But once evictions do start happening again, you're going to find that the process is a lot more detailed than what you've done in the past. The court's going to ask you to provide a lot more information, and therefore we wanted to provide you with a webinar that was more in depth. In fact, our presenters today have presented this webinar to attorneys and judges throughout the state, and we thought it would be great for you to hear it too. Each of our presenters are well versed in evictions matters as they preside over them every day, represent property managers, or represent tenants. And our first presenter is Judge Saloom, who has served on the City Court of Lafayette, Division B, since 1995 and is Chief Judge since November 2018. Barry Grodsky is a partner at the Taggart Morton Law Firm in New Orleans, practicing primarily in the areas of creditor rights and property management. Hannah Adams is a staff attorney in the housing unit at Southeast Louisiana Legal Services. Her office represents tenants and evictions and other landlord proceedings across 22 parishes in the southern region of the state. We welcome them today and hope you find their presentation helpful in your day-to-day real estate practice. With that, y'all go at it.
All right, thank you very much, Kim. Thank you for allowing us to present to your organization. You know, as you and I were talking about it, I used to be a real estate agent. That's how I made money during law school. I had my real estate license, so it's good to be back home. I have, as we started working on this webinar, I could tell you that this was Hannah's baby, and she started the process with the hope that we could get it out just to whoever would listen, and Barry and I have joined her, and I think we put together for you as much information as we know exists on the CARES Act and the governor's stay orders, and when basically, as the question asked, when can we have evictions? And we look forward to answering that to you. We're going to have, as we discuss it, we're going to be talking about the stays and the moratoriums, and we're going to give you a little rundown of when we believe the evictions will be able to go forward. And for your end of the realtors, we're going to be talking a lot about what the expectation of you is going to be. And unlike any other evictions that we've handled in the past, I think your role and the role of the owner is much more important than I think many people imagine. So When we got started talking about this, we've been using the terms the three-headed monster. And so Hannah, I'm going to turn it over to you and let you start explaining to them what we're talking about.
Absolutely. Thank you, Judge. And thank you to the Realtors Association for asking us to present today. The materials that are linked to the webinar, you may notice that they were actually originally created for judges. So a lot of this information may be useful to you because it will give you a sense of what the resources that have been provided to judges to navigate these issues from the bench. So again, my name's Hannah Adams. I do represent tenants. I may have worked with some of you in the past representing a tenant at one of your properties. We've come together to put together some information we're hoping is going to be useful to you. So the three-headed monster that the judge mentioned, the first head of the three-headed monster is the governor's ongoing suspension of legal deadlines. On March 16th, the governor issued a proclamation that is commonly known as his stay-at-home order and contained a lot of restrictions on all of our daily activities. But one of the sort of hidden provisions that has a great impact on evictions is that the proclamation suspended all deadlines and timelines in the Code of Civil Procedure in our state law. So why does this matter for evictions? It matters because there are a number of procedural timelines that are governed by state law that are currently frozen or on hold and will be until that suspension lifts. Currently, the suspension is supposed to lift tomorrow, but like Kim said, we are expecting that to be extended, but we don't know yet because we haven't seen the proclamation. It probably will be issued today. So specifically, as you know, the Louisiana law requires a 5-day notice to vacate for most evictions. And that 5-day period appears in the Code of Civil Procedure. Therefore, that 5-day period is currently suspended and cannot begin to run until after the suspension lifts. Similarly, there's a 3-day period that must be between when a rule for possession, the petition to evict, is served upon the tenant and when the hearing can be scheduled. And that 3-day period also can't begin to run until after the suspension lifts. So I guess for your purposes, probably the most important one is that 5-day notice. So unfortunately, even if you issued a 5-day notice like on April 1st to your tenant, you can't unfortunately run into court on the day that evictions begin again to file that eviction because those 5 days have not begun to run yet, and you have to count them after the suspension lifts. Anything to add to that, Judge or Barry?
No, I think that's right. And I just think from the landlord's perspective, and I come from the landlord and the realtor side, the property manager side, we have to really pay attention to these. Those are the basic rules that we're all been operating under, but both under, with the modification of with the judge's proclamation and what we're anticipating this extension to be, and as Hannah in more detail is going to talk about the CARES Act, landlords and property managers have to be extraordinarily careful with the timing. That's maybe the substance of everything's not changing, but the timing is greatly affected. And overzealous landlords and property managers are going to be hit with actions if they want to move things too quickly. Again, this isn't necessarily a prohibition of if something is filed or you file something, but things aren't going to progress because of these orders. But again, as you go through these, please, pay attention. All this material is going to help to these timing filings. A lot of caution has to be given to that.
Absolutely, Barry. And the one thing that we're excited about talking to the realtors is, we've said this, the lawyers are protected, the judge is protected, the landlord's not. And a wrongful eviction for a landlord could cost them money. And if you're a property manager or if you're a licensed realtor, it could cost you money if something goes wrong and you get part of a wrongful eviction suit. So as Barry was saying and Hannah said, caution, patience are the key things for y'all, because a mistake you make could cost you. A mistake I make as a judge could be reversed by the appellate court, and I can't be sued, and Hannah can't be sued, and Barry can't be sued in the sense if he gives instructions that his client doesn't listen to. So that's why as we go through this process, keep in mind those state timelines and those 5 days and 3 days, because they get lost in the big umbrella of the next thing we talk about, which is the CARES Act. We kind of skip over the Supreme Court stay order because it usually mirrors the governor's order. So if the governor extends it, the Supreme Court usually will extend as well, and that's our anticipation. And that really just binds the courts. We know that the courts are free to have hearings, and we know that people can come into courthouses, but we also know that we have some deadlines and delays that are frozen that the judges have to apply to. So the second monster is really the Supreme Court order, but those are all kind of secondary to the real reason we're talking to y'all, and that's the CARES Act. While I have you though, I want to remind you, if you look on your screen, you should have the ability to ask questions in writing. If you have a question, please feel free to ask it. I'll have it on my screen, and I can read the question, and we'll be answering them as we go along. So Hannah, the third monster, the more complicated monster, I should say. Let's go ahead and talk about that.
Sure. So I'm going to pull up the materials on my screen. Judge, is that showing up?
Yes, ma'am.
Okay, fantastic. All right. So I'm going to just highlight a couple things we've included in here, and then I'm going to move into an overview of the CARES Act, which is, you know, what the real reason why we're here today, and perhaps the most complicated head of the three-headed monster. So I've included, what I'm showing right now is something we call a bench card. This is something that we created for judges and that has been distributed by the Supreme Court to every judge in the state. So you can trust that the judge that you go before on an eviction will have this document in front of them in order to determine whether your property is covered by the CARES Act. So the CARES Act. I'm sure at this point, you know, it's June. We've all heard about the CARES Act. Let's go into some detail about what properties are covered by the CARES Act and what is prohibited by the CARES Act. So as you probably know, the CARES Act was the federal stimulus law that was passed on March 27th. I've linked to the full text if you feel like I'm perusing a 700, plus page law. But the important part of it for our purposes is Section 4024 of the law, which contains a temporary moratorium on evictions for certain reasons from covered properties. And we're going to go into what is a covered property in a moment. There's also a sort of sister restriction in Section 4023D related to forbearances for multifamily properties. And I'll also go into that. Okay, so what properties are covered? There's a sort of two-step analysis to determine whether your property is covered by the CARES Act. The first is your property what's called a covered dwelling? This is the easy part. If your property is, if the unit is occupied by a tenant pursuant to either a written or oral lease, including a month-to-month lease, it is a covered dwelling for the purposes of the CARES Act. In addition, the dwelling must be located in a covered property. So here's the fun part. A covered property under the Act means any property that participates in a covered housing program under the Violence Against Women Act. I'm going to go, don't worry, I'm going to go into what that means. Or a property that participates in the Rural Housing Voucher Program. Or, importantly, a program that has a property that has a federally backed mortgage, whether it be a single family or a multifamily mortgage loan. Now, I want to note here a really important point. The law is very clear that the language is any property that participates in a covered housing program, not any tenant that participates in the program or any unit that participates in the program. So what that means is that even if one tenant at your building has a Section 8 voucher or lives in a tax credit unit, the entire property is covered by this law, which means that all tenants are protected by this law.
And Hannah, that's real important for the realtors, because a lot of times a realtor will have, they manage 1 or 2 condos in a 30 condo complex. It doesn't matter in like an apartment complex if the apartment that they manage is not Section 8, it's the entire property. So if it's a multi-family property, that property is what's covered. It's a little bit grayer when it's a condo that's sold separately, because that's a separate titled property, but the condo itself may have some obligations that are being paid. So Barry, you might want to jump in on that one, because I know the realtors are going to have that handle bits and pieces of a big complex are going to have to deal with that.
Right. There are a couple things too. So I think the point is that the property managers and the landlords have to be aware, if you've got hundreds of units and only one unit is involved and it is covered, remember the statute is in terms of not covered tenants, but covered property. So one covers it for all. And one thing we really haven't talked about too much, let me just mention one thing about the word moratorium. It's a moratorium on eviction. It's not a moratorium of paying rent. So this isn't a statute that says, okay, this is going to be going on for months and months, and therefore during that time, all rent is waived and we start fresh. If tenants want to pay rent, they can pay rent. If tenants can't pay rent, they can pay rent. And we'll get into a little bit later, but at the end of the day, especially on some individuals who are not going to be under a tax credit or Section 8, you may have to have a conversation with your tenants to say, okay, you're paying me $1,000 a month, you didn't pay it for 5 months, that money doesn't go away. So it's not a moratorium on them paying rent. There going to have to be a lot of frank conversations with landlords and tenants about where are we going from here? How do we cover the rent? How do you make it up? I'm not expecting you to write me a check now for 5 months of rent, but maybe over the next year, you could pay me an extra couple, $300 a month, whatever you want to do. And we can, there's all kinds of ways to work these agreements out. So remember what the moratorium relates to. It relates to the eviction. It doesn't relate to the obligations under the lease.
Right. And I think the point we're just making to the realtors is y'all are going to have to do a great deal of legwork to figure out if a property is covered. The individual condo might be paid for in cash, but the entire complex might have a mortgage that's paid by the condo association that is federally subsidized. And to be honest, the CARES Act doesn't quite say in those situations. And Barry, I know you've been preaching in all of these programs, and Hannah, you as well, to be very conservative in interpretations, because if it's a gray area, it's probably going to be read in the most conservative light. And since the governor's worried about it, since the Supreme Court's worried about it, since the legislature's worried about it, it's probably going to be read in the light favorable to the tenant.
Okay. Yeah, let me just reiterate what the judge said before. For property managers, you've got to be aware of this one truth. That is, if a judge, there's no case law to guide anybody, lawyers or judges, and this act has some gray area, which we're going to go through in a bit. But when in doubt, I'm telling my property management and landlord clients that when in doubt, be cautious, because if the judge makes a mistake, it gets reversed on appeal. If a landlord makes a mistake, he gets sued for wrongful eviction. So let us be careful. And sometimes, discretion is the better part of valor. Let's, maybe it might take an extra few weeks or days or something to get an eviction done, but that extra time might just stave off a lawsuit. And we're going to try to give you as best advice as we can, but there's still a lot of gaps in this.
And Barry, everybody, I just want to point out that whether or not a property is covered by the CARES Act is important, because you cannot give notice until, I think, after July 25th.
Right.
And then you cannot file eviction proceedings for 30 days following that notice. So this is why it's so important to know whether your property is covered by the CARES Act. And that will have to dovetail into whatever the governor and the Supreme Court are doing on suspensions of legal deadlines. So I just wanted to make that sure that y'all know that that's why we're focusing on the CARES Act. And I will hand it back over to all of you.
Thank
For
you,
sure.
Kim. Anna, you want to pick up where we left off talking
Yeah.
about?
Yeah,
rentals?
absolutely. So I've listed on the next few slides examples of the types of federally subsidized housing programs are covered by the Violence Against Women Act, and therefore, based on the language of the law, covered by the CARES Act. So it's really all of the HUD subsidy programs, including Section 8, including any of the project-based programs, public housing, permanent supportive housing for people with disabilities. And again, keep in mind, even if just one tenant at a property has a Section 8 voucher, that whole property is going to be covered under the language of the Act. All of the Department of Agriculture subsidized multifamily properties are covered if you live in one of the more rural areas. And then the federal low-income housing tax credit program is also covered. So that means that if the property has any tax credit subsidized units, the whole property is going to be covered, which I know at least here in New Orleans is a lot of our affordable housing stock.
While we're there, Hannah, we had a
Sure.
question, and it was a
Yeah.
great question. I answered it, but just so those that didn't see it, a lot of people walk to their bank, especially in the old days, especially in the rural areas. You walk into your bank and you talk to your friend that's the loan officer, and they'll make you a loan, and the bank will make the loan. They'll fund the loan, and then 2 weeks later, you get a letter from somebody that they purchased the loan package. And if that loan package is sold and it is purchased by somebody that is through a federally subsidized, like Freddie Mac or Fannie Mae, a federally subsidized agency, then all of a sudden the loan that was not federally subsidized becomes federally subsidized, and the CARES Act applies. Another thing is, we were talking about the Section 8 and other things, just so the realtors understand. If you represent a landlord that owns multiple properties that are not in the same location, he may have or she may have one covered property, but the house next door to it is not covered. So we're not saying that the owner is if the owner has any type of connection, it's the individual properties, but unless it's a multi-apartment type complex, a multi-family. So if you represent people that have multiple houses, not in an association, not tied together, then you have to really look at each one individually. But if it's one big multi-family complex, if one person's covered, everybody's covered.
That's absolutely right. Thank you, Judge. Absolutely right. So the rural housing voucher program is covered. And let's just scoot right into the federally backed mortgage piece. So we just discussed how if the property participates in a federal subsidy program, a rent subsidy program, it is likely a covered property under the law. The other category of covered properties is properties with federally backed mortgages, both single family and multifamily. So this is going to be your FHA mortgages, other HUD, Department of Agriculture, VA mortgages, and importantly, like the judge was talking about, mortgages that are purchased or owned by Fannie Mae or Freddie Mac. This information might not.
Business.
What'd you say?
Small business loans.
Yes, and I should add this onto the slide. If you have a small business loan that is secured by the property, that property is covered because that's going to be a federally involved mortgage. And again, this information may not appear on the recorded documents that are in the public record. Like the judge said, 2 weeks after origination of your loan, it might have gotten purchased by Fannie Mae. That might not be recorded information. So you need to look it up in order to be able to answer the questions that the judge is going to have. to see if the property is covered. So I want to provide a few resources to you guys, but before we go into what exactly the law prohibits, which I know is the important part. Let me find it. Here we go. So I've included in the presentation some resources where you can look up to see if the property is covered. I mean, you know, if you are working with the owner of the property, they should be able to access this information fairly easily. There are some databases where the information can be accessed, but especially for single family properties, you probably need to call your servicer, or your client needs to call their servicer to find out if it is a federally involved mortgage. Now, what does the law actually prohibit? Here's perhaps the part that that Kim was getting at. So the law prohibits any eviction filing within 120 days of the date that the law became effective, which was March 27th, for non-payment of rent, fees, or other charges at covered properties. And it also prohibits late fees. That's section 4024B of the law. So again, in a nutshell, if you are a covered property, you can't file an eviction for non-payment of rent, fees, or other charges, and you can't charge late fees between March 27th and we calculated July 25th is the 120 days. After July 25th, you have to give a 30-day notice before you can evict those tenants. So that's effectively going to take you to August 24th. Now, there is a ambiguity in the law, which we, you know, want to highlight. This is going to be an issue that judges will probably decide on a case-by-case basis, where the notice section of the law is silent as to whether notices to vacate are prohibited during the 120-day period for any reason or just for non-payment of rent. This is important because you probably have the question, well, can I evict someone for a reason other than non-payment, like, you know, their dog is barking too much, or they're, you know, they threatened somebody with a firearm, you know, any other type of lease violation. Can you evict somebody for another reason if the property is covered and the eviction falls within the moratorium period? Again, that's going to depend on how the judge decides this notice issue under 4024C and whether notices are prohibited for any lease violation or just for non-payment of rent. Judge or Barry, do you want to add anything to that?
Yeah, you know, we've thrown a lot at you, and so I'm going to summarize it real quick to bring you up, and then we're going to make it even more complicated. So right now, what we've talked about is the governor's stay. We know that all timelines are stayed. The 5-day notice, 30-day notice, 3-day notice of hearing, all of that stayed until at least June 5th, and we believe it's going to be extended either to June 26th or July 5th. We're not sure what the governor is going to do, but we believe it will be. So that's all on hold. That has nothing to do with the CARES Act. So anything that was not run prior to March 26th is frozen. But then we have to move to March 27th. March 27th is the date of the CARES Act. So anything that happened prior to March 27th, as far as the federal government's concerned, doesn't matter to them. It's not covered under the CARES Act. So if it happened prior to March 27th, the CARES Act does not apply. But the governor's stay applies, possibly. So you have to be aware of that. So anything after March 27th, you have to be very cautious to see whether it's a covered property. And simply said, a covered property is a one that has a federally subsidized mortgage or a federally subsidized rental payment. So now we've got you. You understand that there's a stay order from the governor. We understand that there's a CARES Act that's going to run through basically August 25th by the time your 30-day notice applies. What Hannah was just talking about is all of that deals with rentals, but not all evictions deal with rentals. Some deal with other causes, and that's the gray area. That's the area that's going to be for the judges to decide. But also as a landlord, it's going to be something, is it worth the effort? And I think it's all going to come down to not whether rent was paid or not paid, because the judge can always declare that it's a rental issue. It's going to become a material violation issue. How egregious was the violation? If there's a shootout in a complex, under any circumstances, that's a violation. If it is, I think, Barry, you used the example, barbecuing in the front yard, and you're not supposed to barbecue in the front yard, you got to be in the backyard. Nobody's going to care that happened. They're going to point their finger at the tenant and say, don't do it twice. So material violations are going to be where the focus is going to be. And Barry, I know you've had some thoughts on that topic as well.
Yeah, just a couple of things. The logic and the explanation which has been given about these non-monetary defaults and dividing this into material and non-material defaults makes perfect sense, and it may very well be how the judges do this, but that guidance is not in the act. And what concerns me as a landlord, representing landlords and representing property managers, is unfortunately, the act wasn't clear about whether or not this 30-day notice has to give to non-payment violations. If it what I call a one-strike situation where you have, you've got a bunch of tenants harboring felons and they're running a meth lab, that's one thing. But again, if you're barbecuing in your pits in the front yard, not the backyard, that's going to be handled a little differently. The other issue with this is on monetary defaults, and again, we're cautioning my clients to err on the side of caution. But on monetary defaults, there is a 30-day notice. It's clear as clear can be. But what if your lease has a waiver of the notice, and there's a specific code of civil procedure article that says you can waive that? But the problem that what I've been expressing in these programs is you have a state law lease and a state law procedure that talks about the 5-day notice and then the waiver of that. All of a sudden now I'm faced with a state law lease and a federal law that's telling me for monetary defaults, I've got to give a 30-day notice. And we don't know what the answer is going to be. We don't know what judges are going to do. And, Judge Saloon may rule one way, but another judge may rule another way. We don't have the guidance yet to know, is that 30-day notice for monetary defaults going to federal law going to supersede state law? And again, if the judge gets it wrong, it'll go up on appeal. If the landlord gets it wrong, we're going to get sued. So we're taking this a little bit cautiously. Have a conversation, with who's ever representing you, and say, what do you think we should do? How should we proceed? But again, unfortunately, these are gray areas, and until we get some guidance, we have to be, in my mind, I think property managers need to be cautious.
And Barry, that's a great point. We always encourage our members that we can, of course, give general guidance, but with their fact-specific transactions, they need to go to their counsel and talk to them about the details of their situation. We're doing this today to impose upon you the importance of doing that more so during COVID-19, and I will speak out.
Absolutely, Kim, and we all recommend that. And I'll tell you that legal services helps all people that are indigent in many ways. So some landlords are in that, say they may have inherited property, but they don't necessarily have money. So we're recommending to everybody, talk to counsel, let the attorney make the decision. That's why we've done 2 educations for attorneys. So we're trying to get the message out of what this is all about, so attorneys can help their landlord, their clients, stay out of harm's way. And there's just some gray areas that there is no answer. I could say blue, Barry can say gray, and I can say light blue, and we all might be right. And as everybody knows, nobody wants to be the guinea pig. No judge wants to be wrong, but if we're wrong, we're wrong. No landlord wants to be wrong, because then their pocketbook gets open. and no tenant wants to have to move. And once they move, they're not going to move back. So it's a real tough spot we are all in, including you. Barry, we skipped something that I think the realtors need to. We're going to get back to this because we want to make, before you leave us today, we're going to give you everything we know about those 30-day notices and all of that. We're going to come back, but we skipped some topic, Barry, that the realtor is going to be the last one to know. The owner might know, the tenant might know, but if a bankruptcy is filed, nobody ever tells the property manager.
Yeah.
So I know we covered that with the judges, and it dawned on we missed it earlier, and I thought maybe that would be something you want to guide some of the property managers to be sure that their owner communicates with them.
Right. Let me just touch on this just briefly. We expect, and the judge and Hannah have talked about this, the second half of this year, we're expecting a significant uptick in the number of bankruptcy filings. I think the whole economic circumstances is warranting this. And if you look at all the reports and all the data that's coming out, we're seeing this, we're kind of bracing for this, especially when I do creditor work and landlord work, we think we know what's coming. The issue here is we have to be very careful. If a bankruptcy is filed before an eviction is undertaken, you are stayed. You cannot proceed with the eviction unless you go to bankruptcy court, and there's certain remedies there in the bankruptcy court that you can undertake. If an eviction is filed, but there's no ruling yet on the eviction, again, the process is stayed. You can act, and I've had it happen to me during an eviction hearing. I've had a tenant file through their attorney bankruptcy during the hearing, and the hearing came to a screeching halt. And that's not improper as long as the state judge understands, where the bankruptcy was filed. But one thing that is a little bit different is if a judgment of eviction has been rendered, then if the bankruptcy is filed, the bankruptcy does not protect the tenant. Under those circumstances, the lease, there is no lease. It is not part of the bankruptcy estate, or we say property of the bankruptcy estate. There is no injunction, or the bankruptcy term is there's no automatic stay there. In fact, tenants, some judges get a little nervous with this, but I'll tell you that under those circumstances, you don't even have to go to bankruptcy court to handle an eviction. You go straight to state court, city court, parish court, wherever it may be, and explain to the judge the eviction's already happened. Now, I've also had a judge tell me, well, that's not good enough. I want to hear it from the bankruptcy judge, and we've stopped hearings and had to explain a little bit, because bankruptcy does get a little unusual. But again, I think property managers need to be aware that this is going to happen. You're going to see more bankruptcies second half of this year.
And as an agent for the owner, you can't be you're not sheltered. If the owner has notice, you're supposed to have notice. So if you're coming to court and you proceed on a violation of a bankruptcy stay order, that's a big problem. So as you make sure everybody you represent knows that you're on their immediate notification list. I would personally send a letter to all of my clients if I was a realtor and say, I'm managing your property. If you receive a notice of bankruptcy, I need to have it immediately, because you're not on the list from the bankruptcy. I can promise you, on the creditor list, your name's not going to be on it.
Well, I got to tell you just one little point about that too. You don't need to be served with bankruptcy notice. I call this the elevator rule, because if two people are in an elevator, you're with them, and one guy says to the other one, hey, did you hear that Bill filed bankruptcy? And Bill is your tenant, you're on notice. That's all you get. So it's not like being served with a lawsuit. Bankruptcy rules are a little bit different. The automatic stay goes into effect whether you know about the filing or not. That automatic stay goes into effect the instant upon filing. So just be cautious and be wary that you're going to see these.
And I see you smiling, so I know you agree with what we're saying. Be protective if you're and I know as a former defense attorney, nobody wants to set anybody up for failure, but as a defense attorney that's practicing, you've got every issue is important to you. Otherwise, you're committing malpractice, and you're not going to do that. Is that right, Ms. Hannah?
Sure is, yeah. I think, you know, and I think as an attorney who represents tenants, we are, you know, certainly we will be bringing all these defenses in court. And you know, our preference, and I, you know, Barry and I have worked a lot together with him representing the landlord and me or my colleagues representing the tenants. We're always looking for ways that we can work these types of situations out in a way that gets the landlord paid if it's a non-payment issue and keeps the tenant housed. And I think now more than ever before, that's going to really be in the best interest of both parties, because otherwise the landlord's really never going to see that money, and the tenant's going to end up potentially on the street in the middle of a public health crisis. So, you know, not to hold up Barry and my professional relationship as an example, but I think it's really a wonderful opportunity to try to work out stipulated agreements, payment plans, consent agreements, that type of thing.
And I can speak for judges. We always love when the parties stipulate. Now let's put it back into perspective. So we're going to get into the weeds now of when can we file. The governor's stay order is good right now through June 5th. We expect it to be extended. So no time limits run. The CARES Act, if you have a CARES Act covered property, means that it is stayed until August 25th, because the 24th is a weekend. So the 25th, and that includes the 30-day notice. So we know that right now, no evictions are going to be filed. No evictions are going to be heard. And we're going to talk in a second, Hannah, about file. And Barry, no evictions are going to be heard easily through June 10th. But it may get postponed. And if it's a covered property, no eviction is going to be heard till roughly August 28th, and maybe even into September. So how did we get those numbers, Hannah? How did we? So let's talk about that so they understand that.
Absolutely. One, if you'll permit me, just one really quick thing. There is one more eviction protection written into the CARES Act, and that is if you are involved with a multifamily property with a federally backed mortgage that received forbearance, evictions are not permitted, and late fees are not permitted during that forbearance period. And the reason I mention that is because while those properties would have already been covered under the eviction moratorium in the CARES Act that we keep talking about, there is a possibility that your property could receive a forbearance beyond July 25th, which would mean that the protection would actually extend further than the one we were previously talking about.
Right. And Barry, I know that you've worked with many of your clients to get a forbearance, or at least look into the forbearances. So that's something else that the realtors can do to some of their owners, is try to get them, if they're not aware of the forbearance opportunity, to at least look into it.
Right, and that's a good point, Judge. This is a time when landlords and tenants need to start having some frank discussions. Again, I said about this is not a moratorium from paying rent, so that you need to talk to the tenant, say, how do you plan on paying? What are you going to do? You know, the rent's not going away. We have to have this conversation. But when you get to some of these situations where they are, you know, tax credit, Section 8, the dynamic of it might change a little bit. And not jump ahead, but there's one other, some material I put in the handout, or the link, deals with the grievance process. There's a federal grievance process that we're going to see an uptick in this as well, where tenants have the right to come in and assert these types of claims. And that absolutely stops the eviction process. But one of the reasons that that's important, I'm just pointing it out now, is that grievance process requires landlords and tenants to sit down and have a conversation. And Hannah is right. One of the reasons, and I don't know how many evictions I've handled, but one of the things that I try to avoid, even if the tenant ultimately cannot work it out and has to leave, is I don't want to end up with a judgment of eviction. Because as most of you property managers know, or realtors know, or landlords know, a judgment of eviction for those who are receiving federal assistance means that the tenant will lose, I believe, for 2 years, all federal assistance, and then move to the bottom of the barrel for housing. And that could be a 6 or 7 year wait to get back into housing. What we try to do is, if we can't work something out, we will do consent judgments or stipulated judgments that say the parties will agree to mutually terminate their lease and they will move out on a certain date, and it may or may not include some type of a repayment plan. But this is a great opportunity to work with tenants, try to get something resolved. If you can't, understand what their rights are, understand your rights, to try to work something out. Again, it's time for tough conversations, but this is the time to do it, because the courts I think we're all waiting for the for the governor's extension literally any minute. So these evictions really may not get underway soon. Landlords, you want to be protected and get these workouts in place now.
Yep. And Hannah, we're getting some great questions. So we can use these questions as we explain them to explain the next area. Do 5-day notices of at least still apply? And the answer is yes.
Yeah.
If it's not waived, yes, it applies. Now, if you're a covered property and the 30-day notice applies, it's not 35 days, it's 30 days. The 5 is incorporated into the 30. But if your lease does not waive the notice requirement or the 5-day notice requirement, then yes, it still applies. And even if it waives the 5-day notice, the 30-day applies if it's a covered property. So, but Hannah,
Yeah.
what if the 5 days didn't run before March 16th?
Then like we discussed before, if your 5-day notice was given before March 16th and it was interrupted by March 16th, it basically is like a big freeze, and you have to count the remaining days on that 5-day notice after the governor's order lifts, whether that be next week or 3 weeks from now. We're not sure. Similarly,
Right.
if you issued that 5-day notice, say, a month ago in the middle of the governor's suspension, then it hasn't started to run at all. You have to count the 5 days starting when the suspension lifts.
Right. So if the 5 days finished prior to really, it's March 13th because the 14th and 15th are weekends. So if it finished on or before March 13th, then you don't have to start it over. But if you have a covered property, it doesn't matter that you gave the 5-day notice. You're now in the moratorium of the covered property, and you have to give the 30-day notice after July 25th. So even if you gave your notice and it ran, if you're a covered property, you still have to do the 30 days. If you're not a covered property, then once the governor's stay is lifted, then you're free to proceed and not have to re-give the 5-day notice. But Hannah, you have to give the 3-day notice of hearing.
Well, yeah, the court does. The court does.
The court does.
Yeah.
And so you still have to wait, even if your court had a case, you had an eviction scheduled back in March 30th, it's the 3-day notice has to be sent over again. So that anything previously sent is over. It has to restart. The 3-day notice has to restart, not the 5-day notice, because that's already run, or you pick up where it was frozen. But the 3-day notice, because the law says 3-day notice of hearing after service, you have 3 days after the service of the eviction hearing. That means it has to, whenever it's served again, the hearing can't be for 3 more days. So that's the Governor's Act. But one of the questions correctly suggested, because they're covered under the CARES Act, they're still stuck till July 25th and then August 23rd, which equates to the 25th. Barry, is that in line with what you're thinking?
Yes, and when in doubt, I know that we had talked before, like the judges groups and so on, about these hyper technical counting days and whether you count the day of service and so on. I always take, I'm a little bit more cautious. I know what it says. I never count the day of service. I always push it back one more day. When in doubt, it is one more day. But wait, is it okay? Can I just circle away again on one thing, though I think it's important for the realtors? Hannah, but when you had talked, I didn't know if you were going to get into it later, but quickly, if you when you were talking about covered properties and the affidavit that's going to be needed. I didn't know if you wanted to talk about that.
Yeah.
We sure
That's something
can.
I think that the landlord and the property manager really need to know about.
And when
Yeah.
Hannah's doing that or finding that, I just want to know we're coming up on 3 o'clock, but we're going to keep on going as long as the presenters are available and have material that they want to share with you or you have questions. But as Amy said earlier, if you need to hop off, we will be providing a link and allow you to view it later.
Yeah,
Excellent.
so the affidavit that was just mentioned is in your materials. This is essentially a sworn certification that has been distributed to a lot of judges around the state. It's been adopted, I know some form of it by Judge Saloom in Lafayette. It's been adopted by First and Second City Court in New Orleans. So you won't be able to file an eviction in New Orleans without filling this out. And you can see that it basically asks some fairly detailed questions about whether you have confirmed that your property does not have a federally backed mortgage and does not participate in a covered federal subsidy program. And it has to be signed under penalty of perjury. And it's not like you just submit this affidavit and then you're good to go. You should probably expect that the judge is going to ask you questions similar to what is on this affidavit to determine whether the property is covered, which means that whoever goes to court on behalf of the property needs to have knowledge of these topics in order to answer the judge's questions. Am I right about that, Judge and Barry?
Oh, absolutely. Let's break it down even more. Let's start with, can you file the eviction? Now, we know that the CARES Act says no eviction will be filed, but as a judge and as lawyers, we also know you can't stop people from filing things. They have a right to file things. If there's but it's pretty evident that any eviction filed during the governor's stay, or if it's a covered property during the covered period, no court's going to proceed with that if the court's paying attention. So yes, you could probably file it. I know in our court, we're having non-covered evictions that are filed. And if we get one that appears to be covered, well, right now, nothing's being set. But if we get one that appears to be covered, we're not setting it until we get the affidavit that Hannah was just talking about. And as a judge, I've already made the determination from my court, and we've suggested to other judges that the burden of showing that the property is or is not covered rests with the landlord. The judge has the authority under the Code of Evidence, I believe it's 202, that to take judicial notice of a federal law. And since the judges are aware of the CARES Act and the moratorium of the CARES Act, most judges that I've spoken to are going to put the onus on the landlord, on the person filing the eviction, to provide proof that the property is not covered. Because the truth is, the tenant's not going to know what the mortgage is. They'll know that there's a Section 8 property, but that's it. And so to be fair and to make sure that the judge is not violating the federal law by proceeding, we're going to be requiring that the landlords provide this affidavit. We're providing it to the landlords when they request an eviction packet, and our regulars we've already sent it to, and they've been told, listen, the judge is not going to consider setting the eviction until we get this back. And we're only asking for one per property. So if it's a multifamily property, I don't need 8 affidavits. I just need one covering that property, but we will need these. Hannah, Barry, did you have something on that?
Yeah, I just want to pick up what the judge is saying. It's excellent that Judge Saloom and, as Hannah pointed out, First and Second City Courts are doing this. But for over-aggressive landlords who think, well, I'm going to go to some other place and the judge hadn't said anything about this, so I'm not going to use this affidavit, that's going to lead to a problem because technically you're not in compliance with the mandates of the CARES Act. So you need to have this affidavit, whether the court right now is saying, I want this or I need this in some form, you should be prepared. And the other thing that's so critically important is, well, two things really. One is that if you don't do it and the judge calls you on it, you're not going to have your hearing proceed. It's going to get continued. There's going to be delays. So don't try to outsmart the court on these sort of things. They're going to want to move this. But the second thing is, if on a standard monetary default, they haven't paid rent in 2 or 3 months, and the property manager comes in, the property manager has to come in with this affidavit and be prepared to respond to the judge's inquiries about this. You just can't go in and say, got a lease, hadn't paid rent in 3 months, I want my judgment of eviction. That's not really what's probably going to happen on these covered properties. They're going to want to go through this affidavit. They want to, make sure, okay, is the owner under a forbearance agreement? Have you signed off on that? How much longer is the forbearance agreement? What is your evidence of an FHA? Where did you go look to research this? You didn't check off that it's covered. Tell me what you did to go figure it out if it was covered. These are the things I think the judge has a right to ask. So property managers will be ready.
And they will ask, so that's the important part. Now we've told our landlords, we get calls every day, and we just tell most of the landlords we're dealing with, if they know that they're in a covered property, they're not filing any evictions. They're just holding them, because why pay the court cost? Because as we've told all of our landlords, once it's filed with us, whatever court cost is expended isn't going back. It's not being refunded. We'll refund the unused portion, but if you file it with us, then the cost of filing it is taken out of that filing fee. And if you're not going to have a hearing in a month or two, why file the eviction? Because you're just spending your money. The person might move. There's a lot of things that can happen. So whether you file it early or not is not going to make it much of an advantage. It's a business decision. Do you want to file it so you don't worry about it, or you want to hold your money and wait? And we've just been recommending to the landlords, just wait. When these all get filed, I know in our court, we're going to have to figure out how to handle them, because we can't push them off. We have to deal with them. They're summary proceedings. They're not like a regular suit where you can push it off months. So we're going to probably have to have special dockets. We're going to have, but then we're going to have to coordinate that with our marshal's office, because they have to execute the writs of possession. So there's a lot of things the court's going to have to deal with. Our recommendation was, don't file it until we can proceed. And right now, we think we can proceed, but we kind of know that we're not going to be able to on June 10th. Barry, there's a great question here, and I can honestly say I don't think this has ever been posed to us. I have a property that I manage, and the lease agreement is at the end of the term. The owner wants to sell the property. Is it okay to provide a notice to put the home on the market? They do not want to continue the lease to the home. I need to know if this is okay. And that incorporates very multiple issues. If it's a covered property, then obviously the tenant's not going anywhere. Is that right? Wait, you're muted. Barry, I can't hear you.
Sorry, to me, that's almost like an encumbrance on the property, that because even though the lease is now month to month or it's terminated, I don't see any prohibition about selling the property. But when you sell the property, it's still going to be subject to the CARES Act. And, and it's a good question too. Ironically, what would happen if it's a not covered property and the new purchaser buys it with financing, say on a Freddie Mac loan? All of a sudden they're moving into a covered property. So yeah, that'd be a good one too. But I don't see a prohibition against selling the property, but I almost would treat the CARES Act as an encumbrance on at least to the extent you cannot remove that tenant until the appropriate time. That is a good question though.
Yeah.
And I would just note too that the Code of Civil Procedure articles that cover evictions, 4701 and the following articles through 4735, they cover occupants in addition to tenants. So you have to be really careful. You can't just buy a property and throw the tenant out. You have to go through the eviction process, and therefore all of these restrictions are going to kick in.
And if you have, the CARES Act does not require you to renew a lease. But if you have a notice of non-renewal provision in your lease, that's where the lawyers come in, and you really go sit with them and present that question to them. Because the other answer could be the time limit to renew the lease is stayed by the governor's order. So you might be protected. House Bill 805 it gave some deadlines on when timelines that expired during the stay period, they added a new timeline to it. So that's a great question. It incorporates a lot of different issues, but those are the kind of questions that the closing attorney or the seller's attorney, somebody should answer, and not a real estate agent, and because that's just asking too much legal questions, too dangerous a question, excellent question, but too dangerous a question to answer. And if I'm not the agent, couple of things too, Barry. I know we've talked about the in all of these evictions, when you have a mortgage, or if you whether you have a mortgage. This is also an example, Barry and Hannah, of the eviction during the CARES Act for a non-rental cause. So maybe it's a good time for us to talk to them about the non-causes other than non-payment of rent. You're muted.
Absolutely. Would it be good for us to go through that cheat sheet now, do you think, to address that question?
Go to some of those, and I'm going to go through some of these questions and
Great.
send some answers while you're doing that.
Okay.
Barry, did you have something else?
Oh, go for it.
Yeah, no, I just think that the big thing about the non-monetary issue is going to be the 30-day notice, and I really wish that Congress would have listened to the judge's sage wisdom about whether it's a material breach or not, because when you're running a meth lab as a non-monetary default, and you have a dog that's barking too much as a non-monetary default, those are two different things. How they're handled is going to be up to the court, and we're looking to the courts for guidance. But this is a real, it's just not covered. We got to be very cautious on this.
So we created this sort of cheat sheet primarily for judges, but I think it can serve as a useful document for you guys as well when determining when it makes sense to spend the money to file an eviction. So basically what this cheat sheet does is it identifies whether the property is a covered property or not under the CARES Act. So you have to do that preliminary analysis. And then it identifies the reason for eviction. Basically, is it a non-payment eviction, or is it for another lease violation other than non-payment? And then it talks about what notice issues apply and sort of the various timing and CARES Act issues you have to think about. So the first example is a non-CARES Act covered property where the rule for possession was filed, the rule for possession meaning the petition to evict with the court, was filed prior to March 16th, which is when the governor's suspension took effect. And the hearing never happened. It was suspended because of the governor's order. So considering all the delays that result from the governor's suspension of legal deadlines, the first day that hearing can legally be scheduled is June 10th. That's because, as the judge was saying before, in the law, after the constable serves, or the sheriff or the marshal, whoever does it in your jurisdiction, whoever serves the eviction papers on the tenant, there's a 3-day period after that before the hearing can be scheduled. And that period gets suspended by the governor's order. So that's why the third day, meaning the first day that the eviction can actually be scheduled for hearing, is going to be June 10th in that example. Okay, the next example is, this one is probably even more useful for you guys. This is an example where the 5-day notice or the notice to vacate had not run prior to March 16th when the suspension took effect, or it was filed after March 16th. The reason why that's important is because, again, that 5-day period, which already doesn't include weekends or holidays, that period is on hold. Those days do not count until after the suspension lifts. So you have to add those days on the other end before you file. And I'll tell you why that's important, because if you don't do that, an attorney like me is going to come in and file an exception for prematurity and try to get the judge to throw out the eviction because it's too early. Anything to add to that, Judge or Barry?
Nope. That's right. We have to be aware of that. The tenants' attorneys are going to use lawfully and properly every remedy they have. And with this act is laying out these other conditions, and this is changing how property managers and landlords did things before. So it's not business as usual. And if you don't do this, you're going to see these exceptions and these objections filed, which is absolutely going to delay this. So better to take a little bit of caution on the first side, dot I's and cross T's on the first side, so you're not hung up with all these delays. But property managers expect this is going to be the norm for tenants.
Well, as a judge, I can tell you, when the governor makes a point of talking about evictions and the Supreme Court makes a point of talking about evictions, we're going to look at evictions very closely. Not that we will deny a valid eviction, it's just that you're going to look at all the facts. You're not going to treat it as the old evictions that take about 15 seconds to do. Do they pay you rent? Are they still on the property? Do you own the property? And move on. So I believe the property managers really going to need to have their owners close by, and the owner might be the only one to answer those questions. We're not going to get into it because it's a lengthy question, but the unauthorized practice of law, you're going to see, and rightfully so, because just because issues aren't always raised doesn't mean that they're not a good question. And so in these circumstances, in these times, you're going to see a lot of issues raised that don't normally appear. That's why Barry and Hannah have stressed so much to work it out with each other. If you can make an agreement with a tenant and the court accepts the agreement, makes it part of the judge's the stipulation of the parties and part of the judge's order, then that protects the Section 8 rights. It also protects the landlord, because it becomes a stipulated judgment that parties have to follow. And I know, Barry, you indicated you try to use those in 90% of your cases or more.
I'm sorry, you faded out a little bit on me, Judge, on that last one.
You use those stipulated agreements.
Oh, yes.
You try to use those.
The stipulated agreements and consent judgments are a very powerful tool, and they accomplish what it's a win-win, because if tenants aren't able to stay and you've worked them out and they can move out at a certain time, maybe or maybe not paying back a little rent, at the end of the day, that is easier for a tenant to accept because they can move on to other housing than an eviction judgment. It's a big difference. When that court rules on an eviction judgment, there's a lot harsher series of side effects and other things. So again, this is the time to have these conversations with the tenants before the problems really start. But after the eviction starts, it's better to get these things, worked out. There's going to be some I promise there will be frustration on both sides moving ahead and trying to comply with all of these parameters of the state laws and interplay with the CARES Act. And we're going to see more bankruptcies, and we're going to see more grievance hearings and so on. But everyone needs to be patient. And again, the more these things can be worked out, the better everyone's going to be.
And Barry, can you touch on, I know a lot of this applies to both commercial and residential, even though we've been talking about it in terms of residential, but can you touch on commercial evictions for a little bit?
Yes.
Specifically?
Well, and we do a lot of that. Some of the subtle differences are on the commercial evictions. Well, you're still going to have CARE Act issues, but you're not going to have individuals necessarily. You're not going to have companies for getting the type of federal assistance. So that's one thing that you're not going to look at. Although other properties are often covered by federal-backed mortgages. One of the big concerns that we have with commercial evictions, well, actually two things. One is the bankruptcy aspect of this, typically and we're seeing a lot of this, where companies are filing bankruptcies, big companies who have these stores during the middle of eviction cases. And there, the bankruptcy rights are a little bit different, because, you run a bankruptcy court and you do get this protection, but the tenant bankruptcy debtor only really has 60 days within the bankruptcy system to figure out what they want to do. And if they want to stay there, they have to bring you current or give you an assurance of how they're going to get you current. So for those of you all who are managing commercial properties, the bankruptcy thing is see it as a speed bump. It is not an permanent extension. That you do have remedies. One other point, though, I really don't see too much in housing on individuals, is that in commercial leases, a lot of times they say to me, I want you to get the tenant out, but I also want you to sue for past due rent. And you have to be careful. Everything, if you tack a 5-day notice on the door, you tack service for the possession rule, that's not good service to get a monetary judgment. You've got to make sure, even from the get-go, service is proper. You don't get good service, a monetary judgment's not going to do you any good. You also have to be careful and see what your lease says about default rates of interest and how much you can collect. And landlords always have to make a good faith effort to lease or attempt to lease the property to another tenant to mitigate their damages. You just can't let a tenant walk out and let the landlord, and the landlord says, okay, this lease goes for 3 more years. They're going to owe me 3 years of rent. I'll lease it out then. You can't do that. You've got to make a good faith effort to lease the premises out, and that can cap your damages. But again, the general tenets of the CARES Act, well, you're not going to really be worried about too much about individuals in the property being under Section 8 and so on. But the other issues are still going to apply, and you still have got to follow all these other mandates if it's a covered property.
Thank you.
We could just do a couple more examples, just finish up this page. So the next set of examples are related to properties that are covered under the CARES Act. So the first one is easy. This is one where it doesn't really matter what the eviction is for, but the petition to evict was filed with the court prior to March 27th. So that eviction is not going to be affected by the CARES Act, but you still have to look at the state law suspension of legal deadlines, which began on March 16th. The next example is a sort of textbook CARES Act example. So this is your covered property. The eviction is for non-payment. The petition to evict was not filed before March 27th. That means you're out of luck on that eviction until August 28th is the date that we calculated, based on the fact that the 120-day moratorium lasts until July 25th. Then a 30-day notice is required, and then there's the necessary period of time between filing the eviction and when the hearing can be held. The next example relates to this is another CARES Act covered property, and this is where we get into the tricky one. So this is where we get into the evictions where the reason is something other than non-payment of rent. We've been talking about how the law is somewhat ambiguous on this point, and it's really going to be up to the judge as to whether these types of evictions can move forward, because the CARES Act just simply is not clear. The way in which a eviction for a reason other than non-payment would be barred by the CARES Act is if a judge decides that Section 4024C of the CARES Act bars notices to vacate for any reason between March 27th and July 25th. Now, a judge could easily also decide that it only bars notices for non-payment. But should a judge decide that it bars notices for any reason, then the evictions can't go forward because the notice hasn't been given, because it can't be given until after July 25th. But the example you see at the top of your page now is one where the notice was already given and satisfied before the law took effect. And if that's the case, then you don't have to worry about it. So if you already gave your notice back in, say, February, and the notice time period ran, and you just hadn't gotten around to filing the eviction yet, and of course you hadn't accepted rent or done anything else to get the eviction thrown out, then you're probably good to file on an eviction for a reason other than non-payment. But The final example we give is one where the notice, was not given or satisfied prior to the CARES Act taking effect. And at that point, the judge is going to have to decide again whether this notice to vacate is allowed or not allowed before July 25th. And I wish we could give you a clear answer on that, but the law is not clear. And again, we're just talking about evictions for reasons other than non-payment of rent right now. Evictions for non-payment of rent are definitely barred until August. So that was kind of in a nutshell. Judge, do you have anything to add to that?
No, you've been covering. I've been answering questions, and there've been some really good ones. Barry, you might want to thumb through them if you have that. I'll give it to you later. There's a couple that were directed to you. They wanted to talk privately after. The bottom line is of all this cheat sheet is it's going to take some calculations. You have to break things down. And the portions that are in the gray area, we just can't give you an answer. I can't, as a judge, tell you in advance what I'm going to order. I can only tell you as what the law is, and the law is not clear. If it's a covered property and it's for a cause for rent, then you're stuck. There's just nothing we can do about it. I can't ignore the law. If it's a covered property but not a rent issue, then the law says I have to consider the issue and make sure that the issue is not a disguised rent issue. So you're right, Hannah, it's just a gray area. I know as a judge, I'm gonna be looking at the nature of the proceeding. I'm gonna look at the history of the property and the history of problems, and I can't give you an answer because the case isn't before me, but it's going to be something that I'm gonna have to really look at, and especially since most evictions, like I said earlier, are just roll in and roll out. They're not roll in and roll out anymore.
Well, let me mention one thing too. The judge has touched on. I think this is important for the property managers. It's sort of what I would call a pretext issue. Let's say you've got a default that covers both a monetary and a non-monetary basis. And you come into court and say, no, I don't see where there's a 30-day notice for a non-monetary default. I'm just going to go with that. And if a tenant's attorney says, nah, you're using that as a pretext because you're really kicking the people out because they're not paying their rent and they're entitled to a 30-day notice, I don't know what's going to happen there, but I think that property managers should be on the alert that if you've got multiple lease defaults, monetary and non-monetary, and you want to be cute or clever or practice in a way in which you're only advancing the non-monetary defaults, that may be fine, but don't be surprised to see an objection saying that that's a pretext filing. You're really trying to kick them out because of non-payment of rent. You didn't give them 30-day notice, and if you prevail, it's a wrongful eviction suit. So, again, I'm telling my folks to be a little bit more cautious, and if you have, and you often do, have multiple bases for defaults, give it some thought how you want to go, because there's, it's going to be thrown back to the judges at first to see what they're going to do. And then once we get some guidance, then we could, tell our property managers and landlords a little better. But until these cases get to the judges and they make some decisions, we're all in a little bit of a gray area. We'll do the best we can.
Hannah and Barry, there's a last question I see is, what control the property manager can waive fees that they charge. And as I appreciate the CARES Act, whether the landlord or the property owner agrees to waive or not, the CARES Act on a covered property, all late fees and other charges are waived, even if the landlord's silent on the issue. Is that right?
That's correct. Yeah, it's illegal to charge late fees if you're a covered property between March 27th and July 25th.
And it's not just the property manager, it's the owner too.
Oh yeah. Yeah, all late fees or other penalty late charges for late or non-payment of rent are illegal.
Yeah, that's clear in the CARES Act. That's clear.
Yeah.
Kim, I see we're going on about an hour and a half. You got us until you don't want us. That's not a problem. But have we covered things that you believe are that I've tried to answer all of the questions, and I've done them publicly for the open questions. There were some that weren't. The most of the questions, and I'll tell you as a judge, most of the questions I could read, I could sense the frustration. If you talk to me for 5 minutes, you can see how frustrated I am not to be able to get my court up and running completely. The end result of every particular case doesn't frustrate me because that's based upon the facts and the law. But what frustrates me is that we're stuck on hold when I know that I'm gonna have a ton of work to do over the next 6 months. And it's like I see it backing up, but I can't do anything about it. So I share your frustration. I know Hannah does too, and Barry. But it's out of our control. We have to follow the rules. One of my favorite speeches that John F. Kennedy ever did dealt with when he was dealing with Ole Miss, and it was his discussion about nobody universally loves the law, but we have to respect it, and it's just what we have to do. We have to respect the law. We can hope they change it. We've asked them to change it, not necessarily prospectively, but I've made it clear, and I've talked to Kim about it, and I've the same with Barry and Hannah. I'd love to see us close out the cases prior to March 16th because they're in the way. But until somebody that has the stroke to say, okay, Doug, you can do it, says, okay, Doug, you can do it, we just can't. And so I share your frustrations, pass it, talk to your owners. They should not hold you any more responsible than than anybody else, but you need to communicate with them to let them know the issues. And that's why we're taking such a time to share these things with you, because we want you to know everything we know to make a better decision. Kim, you had something? You might.
All right, and Judge Saloom, I thank you for that. And I think that's a good note to end the presentation on. And we thank all our presenters. I do want to let you know today is an education material, but on your advocacy side, we did work with legislators throughout the process with House Bill 805 and HCR 25 to try to get a definitive date that you could start filing eviction proceedings and serve them. However, the legislature was hesitant to put a strong deadline limiting the governor's powers under his executive authority, emergency powers. We did send a letter to the governor's office yesterday asking that he not suspend legal deadlines again and let that suspension run. And in the alternative, we did ask him if he could not do that. He don't let the legal deadlines go much longer, but also to allow you to handle the cases that came up pre-pandemic. So we have been educating you today, but please don't forget that we're also advocating on your behalf, and we'll continue to do so.
And Kim, we might say under 805, it did exclude evictions with a caveat. It said evictions are excluded unless extended by the governor.
And I made many strong constitutional arguments on that matter on behalf of our members. But like I said, the legislature was not comfortable curtailing the governor's emergency powers with an ongoing pandemic.
Yeah, and the judge's hands are tied. I can tell you, no judge, no lawyer wants to receive a letter from the ethics board. And I guarantee you, no judge wants to hear from the Judicial Commission for not following the law. And this is just one of those laws that it's a broad net. And unfortunately, the landlords are taking a beating. And there's just no kind way to say it. But the other opposite thing is true. Is that right, Hannah? That this is going to be an ugly, ugly thing come September, because there's going to be a lot of people displaced. And it's just an unpleasant situation all the way around. And that's why Barry and Hannah have been pushing, get with your clients and let the tenants and landlords figure this out so that it maybe reduce the amount of problems we're going to deal with come September. Hannah,
And I would
Barry,
say,
anything else?
Yeah, I mean, I just, we try to be very approachable at Legal Aid. If you need like essentially a mediator to try to work out a payment plan or something with your client, I really encourage you to refer your clients to us, Southeast Louisiana Legal Services, if they're in the southern region of the state, and Acadiana Legal Services in the middle region of the state. We can often help negotiate a payment arrangement or something of the sort that will work for both parties and get it kind of locked in before things get more difficult. So I encourage people to refer their tenants to us and reach out to us yourself if you think that we could assist with a landlord-tenant dispute that might result in an eviction.
Barry?
No, I agree. It's putting together an agreement earlier than later is prudent. It solves a lot of anxiety. Things are going to get worse before they get better. And you could be as creative as you want on lease workouts. You could defer if you have a long-term lease. You could defer towards the end. You could wait until maybe after the first of the year and add a certain amount back per month. You could ask them to pay 50% at the end of the year, and so much per month until then, and so on. You could be as creative as you want. Be careful, paper it up, document it properly. You don't want to have to have a he said, she said this on the rent and change this. It's easy to amend a lease, and it's easy to enter into forbearance agreements. These are things that you should start early in the process, because as each month rolls by, it's just one more month that's the difficult conversation is gonna take place.
All right, well, we thank y'all. Thank you for all being here with us today. Like Amy said earlier, we will make this available on the website, and we hope it was helpful to you. We know a lot more detail, but as you can see, you're going to be asked for a lot more detail when you have these eviction proceedings. So we hope it was helpful, and you have a great day.
Thank you. Thank you.
Thank you all for presenting too.
Yes, ma'am.
All right. Amy's gonna